what's your name? What's your name?
So what's going to happen if I don't give you my name?
Then you can be under arrest.
If you are going to threaten us with physical violence, you better make sure you're willing to go all the way, because I am.
The way the law works is if the law doesn't say you can't do it, then you can do it.
If you want to lock people up for not breaking laws,
all men are created equal is the idea that if it is wrong for one man to commit an act, it is wrong for all men to commit that act. Too often, members of our government exclude themselves from the ranks of equal men referenced by Thomas Jefferson when he said.
Hello, everybody. My name is Craig Hendry. Today's video is going to be about my persecution out of Boyd County, Kentucky. Tomorrow, I am scheduled to stand before a jury, to stand on trial before a jury of my peers. The alleged crimes against me are disorderly conduct and criminal trespass. Now, these are what I'm charged with. This is not what I'm guilty of. Today, we received news. After I got off of an 8-hour shift at 8 a.m., I drove home, picked up my family, my best friend, Tyler, who is also helping me run this stream, and we headed to Kentucky to stay the night before we had a jury trial. Now, the news we received was from my attorney. He notified me that the prosecutor filed a last-minute motion for a continuance. Now, if I had filed for a last-minute motion for continuance, a reasonable person might speculate that that motion would be denied. The double standard, however, between state actors and private individuals is clear for all to see. Now, before I go on and I tell you guys about why this case shouldn't be continued, I am going to show you the last court date where the judge in this case said to me and to my lawyer that no continuance would be granted in this case. I would like to show you that video now.
Present.
No problem. Good morning, Your Honor.
Good morning. What's your name?
My name is Larry Foreman from Louisville. If we could enter my appearance as attorney of record, I'll be taking over the public defender's office on Mr. Hendry's case.
DPA is released as counsel. All right, we're scheduled for a pre-trial conference. Do we have any resolution? Thank you, Ms. Davis.
Thank you, Judge. At this point, Your Honor, there is no resolution. We do have some discovery that we need to send out. We have been working on getting that prepared, but at this point, no resolution. An offer has been made, but
Does he know of the offer?
are you aware of the offer?
I believe I am, but if we can have it for the record, if you don't mind.
Sure. There's credit for time served offered on both counts. So it's disorderly conduct second degree, credit for time served, so you get credit for the 1 day that he was in. Same for the criminal trespassing third degree, for which he was charged.
Okay, and what is the outstanding discovery that we still need to receive?
We have been, we're serving discovery. We
Right.
drafted some discovery to serve on you.
I think he's asking, what is it?
Yeah, just what the nature is of it.
Just some interrogatories and requests for production of documents.
that have been sent in by the public defender's office requesting you to submit on this case, if I understand you correctly?
We are drafting a set for.
For us
Yes.
to respond to?
Yes.
Understood. Okay, so we do need more time for the
Yes.
Commonwealth to be able to draft those, send those to us so that we may respond.
I'm gonna give it one more pretrial. That's it. This case has been going on. This occurred back December the 2nd, 2022. This is a B misdemeanor. So I'll give you one more pretrial so you guys get whatever discovery you think,
Absolutely.
and then we'll set it for trial if we don't have a
And
resolution.
Your Honor, counsel would be happy if the court, to entertain the court, since I know this is a pretty old case, if the court would like to set, so we have a jury trial date on the calendar today, I would be happy to do that.
All right. So you want to go,
I think in May.
can we go sooner? Can we go April?
We can go April.
Can you go anytime in April?
I have some late April dates.
What I have
Okay, Your
available in April is April 3rd, April 17th, and I have May the 1st. So we're gonna try this on a Wednesday.
Let's do May the 1st, Your Honor. And a final pretrial conference, when would that be?
Well, I normally don't do that. Since we've given it a jury trial, that's the next court date we'll have. If you want to put something back on the docket, you can either do it by an agreed order, you can file a motion, a change of plea, whatever, but I'm not going to give you a pretrial and a jury trial.
Understood. Thank you, Your Honor. And just one last question, and I don't know if this is more appropriate for the prosecution or the court. The arresting officer in this case was Deputy Runyon, is that correct?
Yes, I believe so.
Have any charges been filed by the Commonwealth against Deputy Runyon?
No.
Assault charges or anything like that?
No.
Okay. Those are all the questions I have, Your Honor. And those are all the cases I have before the court, if I may be excused along with Mr. Hendry.
You're excused.
Thank you, Your Honor.
Next case.
All right. So what you just saw was the last hearing in this case. The judge, Mr. Reese, the most honorable Mr. Reese, did say that there will be no final pretrial, that there will be no continuances in this particular case. Now, he has agreed to hear arguments, as opposed to keeping the jury trial scheduled. He has agreed to hear arguments from both sides, the prosecution and my attorney, Mr. Foreman, as to why this case should either be continued or should not be continued. Now, coming up here has been a very costly journey. I've had some help along the way, but it is extremely costly to travel 300 plus miles and get a couple of hotel rooms for me and my friend and my family. So this is a very damaging incident if I have traveled all of this way for literally nothing. And so my attorney spent a long time today drafting up a opposition motion to the Commonwealth's motion to continue. And I will read a little bit of that now. Now, I want everybody to keep in mind, this is public record now. This has been filed with a court of law. I'm not reading you anything that has not been divulged to the public. We are, as it stands, set for a jury trial on May 1st, which is tomorrow at 1 p.m. I want to make it very clear that we are, as of now, still scheduled for a jury trial. Now, I am going to read to you our objection to the Commonwealth's motion to continue. Comes now the defendant by and through counsel and moves this honorable court to deny the Commonwealth's motion to continue the May 1st, 2024 jury trial. A continuance of this trial would heavily burden Mr. Hendry, despite the Commonwealth's baseless and frivolous claim that a quote, continuance of this trial will not unduly burden either party, unquote. See Commonwealth's motion to continue dated April 29th, 2024, which was yesterday. Mr. Hendry reasonably and detrimentally relied on the court's assurance on the record on February 12th, 2024, stating, quote, this is an old B misdemeanor case, unquote, and that, quote, this case is from December 2nd, 2022, that no more continuances would be granted in this case due to its age. See court footage from April 12th, 2024. Furthermore, the court failed to grant one final pretrial conference at the request of the defendant and set a trial date of May 1st, 2024. The court indicated that if the defendant had any motions before the court, they are welcome to put them on the calendar ahead of time. The defendant has no such motions. As a result, the defendant, Mr. Hendry, reasonably expected the jury trial to occur on May 1st, 2024, and made the following arrangements in preparation for his jury trial. He had to drive 305 miles one way from Brazil, Indiana, a 5.5-hour drive to Boyd County, Kentucky the day before, a drive he will make back as well once the jury trial concludes. He had to take 2 days off of work to attend his trial and had to inform his boss ahead of time of the same. And this is true, everybody. I had to inform my boss at my 9-to-5 job that I am unable to come to work because this trial was set 300 some miles away on a date of May 1st, 2024. And I had the reasonable expectation that it was going to occur on this day. The court, the judge, assured me that no more continuances would be granted. He had booked 2 non-refundable hotel rooms for April 30th, 2024, in order to timely be present at the May 1st, 2024 jury trial date. And he had a potential witness from Washington, D.C., who booked a flight and a hotel to appear at the May 1st, 2024 jury trial date as well. The Commonwealth is also aware of the fact that the court stated no more continuances would be granted due to the age of this case. However, they have misrepresented to the court an agreement that never happened in their motion to continue. In the mediation that took place on April 8th, the parties discussed a potential resolution. However, the Commonwealth indicated that they needed to further discuss the matter with the police officers involved and would get back to opposing counsel and the defendant about any potential next steps. On April 10th, 2024, the Commonwealth's attorney, Mr. Dotson, emailed a draft of the proposed diversion agreement to defendant's counsel, Mr. Foreman, who immediately forwarded it to Mr. Hendry for his review. Now, I want everybody to understand, a diversion agreement was offered to me by the Commonwealth of Kentucky. I decided, after thinking on it for a long time, that signing a diversion agreement, one of the stipulations of which is that I cannot be charged in the county of Boyd in the Commonwealth of Kentucky 365 days past the agreement date. I decided that if I had to do anything in order for the Commonwealth to do the right thing, that I would inherently be doing the wrong thing. I therefore decided, in the interest of freedom, in the interest of transparency, and in the interest of both parties defending what they believed in, me defending my rights, and Mr. Foreman defending my rights, and the Commonwealth defending the tyranny that was imposed upon me against my will under the threat of force on December 2nd, 2022. Now, if anybody, Tyler, can you work on getting that video up? The December 2nd, 2022 video on my Hendry channel. We want to show you all what this court date is about. I don't want there to be any split hairs here. This is a very important case. Whether you like me or hate me, my actions in the times during the times of question do not rise to the level of criminal. They don't even rise to the level of wrong. Right? So, and that's in any case. But Mr. Dotson, the prosecuting attorney in this case, has decided that after I have stayed up for 48 hours just to make sure I get here on time, that I've spent hundreds of dollars ensuring that I get here on time, ensuring that my family has proper amenities before they are forced to appear in court with me. They aren't forced to, but they want to support me, and I love and I respect them for that. And of course, I'm going to make sure that they have reasonable amenities so that they can enjoy their time up here as much as possible. But the real reason we came was because this is a 5.5 hour drive for us. It took us about 6.5 hours to get here, including stops. I had to drink quite a bit of coffee just to make sure that I drove correctly. But Mr. Dotson assures the court that this will not be overly burdensome to me. No, because he doesn't face the same issues that I face. Of course, when you're on the prosecuting end of injustice, it tastes a lot sweeter than when you're on the prosecutee's side of injustice. So, Tyler, just give me a thumbs up whenever you found it. It will be on the date of April 2nd or December 2nd that it was uploaded. Now, everybody, I want everybody to understand a few reasons why we did not accept the diversion agreement, on top of the fact that it would compromise my principles, okay? Everybody should understand that when we agree that we won't do anything wrong again, we have inherently admitted to wrongdoing before. I haven't done anything wrong in the county of Boyd, in the Commonwealth of Kentucky, to be treated like a criminal. There have been 2 arrests. There has been 1 arrest warrant issued since I've been out of jail in Boyd County. I was arrested in Boyd County, Kentucky, 1 time on December 2nd, 2022. The paperwork was iffy, and it seems to me that the prosecution doesn't want to go to trial because they're going to have to say to 6 jurors that they are defending a cop essentially kidnapping a man for exercising his freedom to criticize government officials. This rises to the level of criminal in their own estimation. It rises to the level of a civil atrocity, right? I think, but most importantly, it rises to the level of disgusting. And I want to tell you why, because in the mediation that we had on April 8th, Mr. Dotson repeatedly offered me a deal in which he would drop the charges in a very short period of time if I would but sign an agreement saying that I am not allowed to sue the Commonwealth of Kentucky for their actions. Now, I'm not obliged, I am not under any obligation to keep that confidential. It is what it is. He offered me that deal. Tyler can vouch for it. Tyler was present at the time that it was happening. Now, what this does, that's it. Okay. What this tells me is that Mr. Dotson is willing to put his reputation, he is willing to put the very Constitution of this country on the line to defend the unlawful criminal actions that were carried out by the police officers, by the sheriff's department of Boyd County, Kentucky. He was willing to put his reputation and the very Constitution on the line to defend these actions. Obviously, his reputation and the Constitution is worth less than the respect he demands or that he commands from the police department. Now, I want to show you the actions. Tyler, can you find the relevant part of the video in there? Don't be shy just playing it because my mic is the only one that's on. So we want to show you the actions of this police officer. We want to show you the actions that Curtis Dotson is so scared to defend in court that he asks for emergency continuances, claiming that his witnesses are subject to emergency surgery either on that day or shortly upcoming. I'll be honest, I haven't read the motion to continue. I have only heard secondhand from my attorney what it says. Now, I feel terrible for anybody who has to undergo emergency surgery. But the fact of the matter is that my rights were violated. I was taken to a cage. I was dragged back and forth from Indiana to Kentucky several different times at my own expense, I might add. This is a very costly trip every time that we make it. And they want to delay the trial because one of the people who kidnapped me has an emergency surgery. Now, I want to ask people in the chat, what do you think would happen if I, a defendant, asked any court for a continuance of a jury trial in which the judge has already verbally stated that he is not going to continue? If I was so audacious to ask a court for a continuance because I had a surgery coming up or because I had a medical issue, it would be struck down, in my opinion, so quick that I wouldn't even be able to blink an eye. But and by the way, no decision has been reached on this. We are still set for jury trial on May 1st, 2024. That is tomorrow at 1 p.m. I've been saying 10 a.m. in other live streams. I was wrong. It is 1 p.m. And we are gonna go and we are gonna defend our position that we have the right to criticize government, that we have the right to do anything we want to, as long as it is not prohibited by a statute, by a state, federal, or local statute. And we stand on that position. And we're standing on that position for you, for us, for everybody in America. As a matter of fact, for everybody in the world, right? We want to raise awareness. We want to show everybody just how far governments are willing to go to violate your rights, to defend the actions of their agents. So with that being said, Ty, where are we on that video? You about ready with it?
Yes.
Okay, we are about to show you the footage of me being violated, of my rights and my person being violated in such a horrendous manner for speaking the words, "This is how you try to talk to people, you fucking thug." Sorry for bleeping myself out there. This is a family-friendly live stream, even though the things we're talking about are certainly not family-friendly. So that's what I said, and I was then consequently arrested for it. Ty, are we ready for it?
Yep.
We're going to show you the video now. Viewer discretion is advised.
We don't want to cause problems. I'm a private journalist.
Let's get outside here and make it work.
Well, why?
Can't we talk right here? I have to talk to you.
Okay, we can talk right here, man.
There's business going on here. Let's go
Yeah,
out
yeah.
here.
Well, there's business going on. Like, I don't know what this is all about, guys.
Now,
What do you mean now? Is that an order? Is that an order?
let's go out here. Yes, it is.
Okay, what's going to happen if I don't?
That's up to you.
No, it isn't. I'm not going to force you to violate me. I have a right to be here.
Let's go outside here and we'll talk about you.
Hey, okay, you can't. You're gonna physically assault us because we want to see the clerk of court? Are you really doing this? Because we trying to see this.
This is how you try to talk to people?
Yes.
You fucking thug.
Okay. That's enough.
Oh, what's going on here? Oh my.
You getting all this?
Yeah, I wanted to see the clerk.
Yes, you are seeing this correctly. This man got put in handcuffs and is about to get arrested because this cop's feelings got hurt. Houston versus Hill is supposed to protect us from this very thing. The Supreme Court ruled that anything prohibiting verbal abuse against police officers is unconstitutional, and it falls under protected speech. And what makes this situation even worse is that this tyrant is proud of what he's doing, hard telling what he has done to other people off camera.
I asked you to step outside.
You did. That wasn't a legal order if you asked.
You're about to mess up big time. You can't just arrest people for asking a question.
And, maybe we'll retire here one of these days. And I'm next door to your office. I hope you got that too.
Okay. So you can call us morons, but when he calls you a thug, you put him in handcuffs.
I'm not going anywhere.
Why?
Yes, I know.
The other arm did not take you on in. I tried to talk to your partner. We tried to have a reasonable conversation. Why you get
I am horrified by what I just watched. I stepped away and I watched that on the laptop. Every time I see it, it makes my heart rate go up. And I apologize if it made anybody at home's heart rate go up. I know that we have an average viewer age of about 40 some years old, and it's not old, but that means that we have some 80-year-olds out there who might have some heart trouble, and I apologize if that caused you any trouble. Now, I want to finish reading the motion to, or our objection to the Commonwealth's motion for a continuance. So, and this is, we're not jumping around too much here, but I want to remind everybody that a mediation took place. This mediation is not an official court date. It was set up between my attorney, me, and a couple of attorneys at the Commonwealth, the Commonwealth's Attorney's Office or the County Attorney's Office. We met up with these people, and they wanted to have an agreement made, but no signatures were given. There was no official agreement entered into. As a matter of fact, the Commonwealth insisted that we give them a few days to ponder the agreement. So we are going to continue on. In the mediation that took place on April 8th, 2024, the parties discussed a potential resolution. However, the Commonwealth indicated that they needed to further discuss the matter with the police officers involved and would get back to opposing counsel and the defendant about any potential next steps. On April 10th, 2024, 2 days later, the Commonwealth's attorney, Mr. Dotson, emailed a draft of the proposed diversion agreement. Proposed is the key word there, people. This is not a formal agreement that we've entered into. This is a proposed agreement. All right. Now, they sent a draft of the proposed diversion agreement to defendant's counsel, Mr. Foreman, who immediately forwarded it to Mr. Henry for his review. On April 26th, 2024, after finally hearing back from Mr. Henry, Mr. Foreman informed the Commonwealth that Mr. Henry did not wish to sign the diversion agreement and wished to proceed to the jury trial. Okay? That date was already set on the court's calendar on May 1st, 2024. It is not Mr. Henry's fault that the Commonwealth falsely and detrimentally relied upon the mediation that took place on April 8th, 2024, without waiting for a resolution and fully executed written agreement between the parties. The Commonwealth improperly and wrongfully perceived the mediation as resolving the case without Mr. Henry's signature. And as a result, they falsely and untruthfully informed their witnesses, the police officers, not to come to trial. By their own admission, the Commonwealth had to consult its officers before sending over the diversion agreement, which is attached. While the parties did discuss a tentative resolution during mediation, no agreement was reached, nor was any agreement signed by either party. I want to make that clear. I didn't sign it. The Commonwealth didn't sign it. There was no written agreement between us at any time, at any time at all. Right? Finally, the Commonwealth is the agency pressing the charges against Mr. Hendry. Mr. Hendry is not moving forward out of his own volition. If the Commonwealth does not believe in its case, then it is free to dismiss the charges at any stage of litigation. Wherefore, for the foregoing reasons, the defendant, Mr. Hendry, respectfully objects to any motion to continue and will be ready to proceed with his jury trial on May 1st, 2024 at 1 p.m. by order of the court from February 12th, 2024. Out of respect for the court, I have shown up here on the date that they told me. I've shown up here the date before they told me. I intend to be at court before they told me. I intend to be early. I intend to dress in an appropriate manner. I intend to act in an appropriate manner. And I intend to defend freedom with everything in my power. And I have a very, very reputable attorney in Larry Foreman who has told me he is dedicated to the same. Now, I want everybody to leave me a comment in the comments below, whether you're coming to this jury trial May 1st, 1 p.m., not in the live chat, I won't see it. I want you to go to the comments below. I want you to tell me in the comments whether or not you are going to be able to attend this trial. I want to see you there. I want to see as many people as we can see there. We have got a few people coming. Those people are very good people. I'm very familiar with them. The people that I know are coming. If you are coming and I don't know you, I'm sure I'd love to meet you. And this is whether you dislike me or like me. I always love an opportunity to change a few minds. So with that being said, everybody, I am going to sign off here. I want to give a big shout out to Ty Reviews. He is streaming this on his channel as well. If you haven't already, I want you to go subscribe to him. He is helping me out with everything I'm doing. He's come up here to show his support for me in this case. He is a great friend. I want to give a shout out to Erica, my girlfriend, who has come to show support for me and to be there for me in a time of extreme difficulty, we'll say. And I want to give a big shout out, not necessarily a bigger shout out, but a big shout out to my attorney, Mr. Larry Foreman, who spent a good majority of his day trying to respond to this crazy, untimely motion filed by the state in an attempt to make sure that I get a fair and speedy trial, right? So with that being said, everybody, thank you all for being here. Thank you all for your support. Before I go, actually, I want to give a shout out, a massive shout out. After a live stream yesterday, I received a donation of $500, just out of the blue. And I don't think it would be right if I left this live stream without giving a massive shout out to the gentleman that did it. His name is Mr. Oldenburg. I want to give a big shout out to Mr. Oldenburg. Mr. Oldenburg, if you would, comment in the comment section below. I want to pin your comment. I want to thank you very much for your donation. That is extremely generous, and it is going to help us towards attorney's fees and fighting against this terrible injustice that is being imposed unwillingly and against and without the consent of the American people. And the tyranny is being enforced on the American people. So with that being said, everybody, thank you for sticking with me. Sorry for being long-winded, but I hope to see you at trial. I hope to see you at trial. We'll see you there. Take care.